The civil procedure question from July of 1988 contains a couple of very difficult issues. Once we get into them, they're actually not that difficult. But given that these are somewhat unconventional issues, we'll have a look. There's a good chance that these issues could try to bite you on the next bar exam. Take a look at the call of the question. Was the court correct in 1. Denying Dan's motion to make Truckco a party and allowing the case to go forward without the presence of Truckco? Discuss. 2. Granting Price's motion for a physical examination of Dan? Discuss. 3. Allowing the jury to consider the issue of contributory negligence? Discuss. Well, let's think for a moment about each of these calls of the question. Look at call of the question number 1. Here we've got a defendant, Dan, we assume D is for defendant, trying to make Truckco a party. Well, if it is for indemnification purposes, we know that supplemental jurisdiction might allow a defendant to bring another party in. We'll have to have a look and take care to make sure that we analyze the facts carefully. 2. Grant Price's motion for a physical examination of Dan. So we've got a plaintiff who wants to look at the defendant physically. It'll depend on the facts. Certainly, a court does have the authority to grant such an order. 3. Allowing the jury to consider the issue of contributory negligence. Well, we don't have to read the fact pattern to know that a judge has quite a bit of latitude to present the issues to the jury. So, if contributory negligence is something that came up at trial, certainly the court could instruct the jury on that point and allow them to consider it. So, here we've got a call of the question that at least breaks down into different categories, but it isn't really as helpful to us as other CivPro calls of the question. So we've got to do a little bit more thinking in order to come up with the issues. Fortunately, the examiners make it a little easier for us as we look at the fact pattern. So let's check it out. In paragraph 1, we see that this is a somewhat novel accident. It's an airplane versus automobile collision. In paragraph 1, we get all sorts of facts about state A and state X and state Y. Actually, state A isn't there at all, but X, Y, and Z are. And so we're going to need to keep track of the different states and which actions are connected to each of them. In paragraph 2, we learn about Price suing Dan in federal district court in state Z based on diversity jurisdiction. We may have to analyze that as well. The complaint alleges negligence and a specific act of negligence, alleging that the carelessness by the defendant caused the crash that injured the plaintiff. In paragraph 3, Dan doesn't appear to contest jurisdiction. He files an answer denying negligence. Neither the complaint nor the answer made any allegations of contributory negligence. Well, we can look to the future and see the third call of the question. If something came up about an issue that wasn't mentioned in the pleadings at the time of trial, the judge certainly has got the authority to allow the jury to consider it and to write or make use of other jury instructions that are relevant to that point. Now look at paragraph 4. This is a long, complicated paragraph, relatively speaking, and we've got to find a home for these details. We've got Dan, the defendant, filing a motion requesting that Truckco be made a party on the ground that Truckco is indispensable. Well, have a look at that word, and it should trigger the appropriate issues. We'll see how it plays out below. Truckco is incorporated in State X, so Truckco's presence would threaten diversity. Truckco conducts no business in State Z, but its trucks sometimes do use State Z highways. The court denies the motion on the ground that it has no jurisdiction over Truckco and that even if it did, service of process would be difficult. That seems a little questionable, but we'll examine it in greater detail. In the following paragraph, we get the request for an examination of the defendant, and then after that, the pretrial conference in the following paragraph. Again, no discussion of contributory negligence. Then, next, at trial, evidence is introduced from the defendant with no objections, showing that the engines had failed without any known cause and thus presented a sudden emergency and that Dan couldn't see Price's truck because of the lack of lights. That's the comparative or contributory negligence issue. It came up at trial. It wasn't pled before. And then, over the timely objection of the plaintiff, the court instructed on contributory negligence. And then we get the call of the question again. So this is a complicated Civ Pro problem, and it's also difficult because of the issues presented and because it doesn't make for terribly easy organizing. So take a look at the outline of issues that I present, and you'll see I find a home for a lot of legal details. We start off by considering whether the court was correct in denying Dan's motion to make Truckco a party and allowing the case to go forward without Truckco. So we first focus on whether or not Truckco really is an indispensable party. And we judge whether or not a party is indispensable really from the point of view of the plaintiff, not the defendant, here Dan. So let's look at Truckco. Is Truckco an indispensable party? Price can get full relief without Truckco being present. Truckco itself doesn't need to be a plaintiff, although perhaps that would be helpful, and joining Truckco as indispensable, as a party plaintiff, would destroy diversity. Now, it seems to me, in fact, that the court does have jurisdiction over Truckco, not just because of territorial jurisdiction, where there is minimum contacts, but also subject matter jurisdiction. And I don't think that the court really has a problem with service of process when we have a look at it. We can serve Truckco at the state X place of business. We'll revisit this analysis a little bit more in a couple of minutes. Next, we turn to the physical examination issue. And perhaps I am writing as a defense lawyer again. It seems to me that the plaintiff doesn't really have a cause to make this motion, and that the physical abilities of the defendant really are not at issue here, since the plaintiff is alleging a mechanical failure as the act of negligence on the part of the defendant. Now, I can tell you that a lot of good answers reach the opposite conclusion on this point. I guess there's a lot of plaintiff's lawyers out there taking the bar examination. But actually, it's an important point to touch on. A lot of reasonable people can differ about their answer to question 2. And I can't even say that there was a plurality correct answer here. It was pretty evenly split, as far as I can tell, even among successful bar candidates. So I want to give you that caveat. Then we turn to the contributory negligence issue, and notice the way I organize it. Driving without headlights, in fact, is negligence per se. It violates a safety statute. The court has the authority to revise issues presented to the jury based on what comes up at trial, so I conclude the court is correct. And that brings us to a brief consideration of my model answer. 1 or 2 highlights are worth having a look at briefly. And I think it's a pretty straightforward answer, even if the question itself presents issues in a somewhat complicated manner. So we start off with this issue about Truckco. I lead with the facts. Under 1A, I indicate what Dan's allegations are, and I indicate that if Dan's allegations are true and that Truckco is indispensable, then the party has to be joined and the court has to dismiss the case. Now, I examined the case from the point of view of the plaintiff, not the defendant, as one should, and I touch on the issue of indemnification and supplemental jurisdiction. And you can have a careful look, and I think you'll find that my analysis is very much on point with the law, and I don't make it any more complicated than I need to. So now we consider Truckco as a plaintiff. It would be helpful to have Truckco present, but it is not necessary. And joining Truckco would destroy diversity, and it would require the case to be kicked out of federal court. I think the court was correct in denying the defendant's motion. So I guess I don't always come down on the side of the defendant. So we continue to consider the court's jurisdiction over Truckco. I find a home for all of the details about territorial jurisdiction, subject matter jurisdiction, and service of process. And I am thus able to fairly significantly second-guess the court's reasoning on the decision that it made. Next, we turn to my analysis of the physical examination. Here again, I don't have anything new to say, but I just want to repeat the caveat, which is, if you disagree with me, you're not alone. there's a lot of disagreement among successful candidates about the answer to this part of the question. I think that my reading of the facts is certainly plain and accurate, but perhaps a more subtle reading would reach the opposite conclusion. So I'm not pretending to be the sole authority on who is right here. But I do reach a conclusion that I think you'll agree at least is supported by my analysis, even if it is not supported by your legal reasoning. So we move on to the contributory negligence issue. And here, this is quite straightforward. And our reasonable intuition about this issue, just based on reading the call of the question, turns out to be a pretty good one. So, ultimately, the last issue in the fact pattern, the last call of the question, is the easiest. And it's the others that require us to do a little bit of thinking. But I think you'll see, particularly after you review a few more of these questions with me, that supplemental jurisdiction really is one of the more subtle and important issues in civil procedure, and one that is well worth your being very thoroughly briefed on.